David Shestokas is a constitutional scholar, and he has books you can see back there on the table. He has done radio programs. You all have a bio of his inside your programs. That'll give you the full rundown of where he's been and the extent of his experience. With that, I'd like to turn the floor over to David Shestokas, our guest speaker. David? Yep.
Thank you, Jim. Can everybody hear me? Good morning.
Good morning.
How are you today? All right. Well, this is wonderful. This is a great opportunity. However, after Dr. Moss describing the history of the Bill of Rights and those two fabulous explanations of the difference between a republic and a democracy, I think we'll just have some coffee and donuts and maybe move along a bit, because it was just really, really great to hear how that was started. We're going to start with a question, and if Reverend Nixon is going to be passing out little cards, little index cards before you do write your answers down. And for those first five that we wind up with the right answers, while we get the technical details taken care of, we're going to have a little prize at the end. I am going to tell you that the question I'm about to ask, only 1 in 1,000 Americans are capable of answering, although it is a question that every American should be able to answer. So we're going to challenge you a bit at the end of my presentation, and we'll collect these in a few minutes, and then at the end of my presentation we'll pick the first five that get them right. If we don't get any complete rights, then we'll get the first five that are the closest, as the case may be. The question is for you to contemplate over the next couple of minutes while I do a little introductory remarks, is what are, in fact, and you just heard them maybe 10, 15 minutes ago, but what, in fact, are the 5 rights that are in the First Amendment? There are, in fact, 5 rights that are listed in the First Amendment. And as I said before, only 1 in 1,000 Americans is capable of answering them. When I do some of this presentation at colleges and universities, I indicate to the students there that they can go win bets in a bar for most of their university career and save themselves a lot of money. But for the time being, we're going to ask you to do that. We're passing out these cards, and if you could fill them out, and then in a few minutes we'll collect them, and by the end of the presentation, we'll talk about that. We'll talk about what those are and why only 1 in 1,000 Americans are capable of answering those. Bit of background on myself. I'm an attorney. I've been an attorney for about 30 years. Before I was an attorney, actually, my family had been in the beer business for a long time, and I actually grew up selling beer, so I think at this point in time, I've probably sold beer for longer than I've been a lawyer, so I think I consider myself more a beer guy than a lawyer, and hopefully that makes it so I can talk to people a little bit different than other lawyers might do. Now, a major reason for we're going to be talking today about the Bill of Rights, and major reasons for the Bill of Rights is among the things that Dr. Moss explained. But you can't really understand the Bill of Rights without understanding a little bit of history, a little bit of philosophy, and a little bit about some stories of people, because every word in the Constitution, including the Bill of Rights, has a backstory to it. And during the course of the day today, we're going to mention a couple of presidents. We're going to mention a saint. We're going to talk about 2 guys that actually got in some trouble with the law. That as a result of their trouble with the law, we have some indications of how some of the Bill of Rights are executed and applied in these current days. September 17, 1787. Would lead to December 15, 1791, which was among the greatest achievements in the history of mankind because it affirmed the inalienable rights of man, rights that we're born with under the laws of nature and nature's God, and placed specific limits on the ability of government to interfere with those rights. When they proposed the Constitution, as Dr. Moss indicated, there was not an easy road to follow for ratification. There were many, many people that were in fact opposed to the Constitution. One of the reasons that they were opposed was that there was no guarantees of our inalienable rights that were built into the Constitution. These two camps were known as the Federalists, who were in favor of the Constitution, and the Anti-Federalists that were opposed to the Constitution, primarily because of the lack of the Bill of Rights. And so the guys that we were talking about, we often talk about the famous guys, Hamilton and Jay and Madison, who wrote the Federalist Papers, and we rely on that in many ways to interpret the Constitution. But the guys that we have to thank for the Bill of Rights are more the Anti-Federalists. They're more the guys. They're more like the folks, Gouverneur Morris, who in fact ultimately wrote the preamble, wound up being opposed to it. Patrick Henry, "Give me liberty or give me death," was opposed to the Constitution because of its lack of Bill of Rights. We have the Anti-Federalists to thank for the Bill of Rights. In order to achieve ratification, the people that were in fact in favor of the Constitution, the Federalists, promised to the Anti-Federalists that in fact, if the Constitution were adopted, then they would pass a Bill of Rights. We hear a lot of those kinds of promises from politicians, right? Right? Senator, nothing.
Correct.
You know, if you elect me, I'm going to do this, or we have to pass the bill before we know what's in it. Those kinds of things. Well, there's a good lesson here because the Federalists, led primarily by James Madison, who is known as the father of the Constitution and the father of the Bill of Rights, once they won election in the first Congress, did in fact follow up on the promise that they made. They made the promise. They had won great majorities in Congress and really didn't have to do this but they had made the promise that in fact if the Constitution were ratified, they would propose and send out to the states for adoption a Bill of Rights. As Dr. Moss mentioned, Madison originally proposed 19 different amendments. Those 19 came from a conglomeration of recommendations of states in their resolutions. And then ultimately the Congress passed along 12 of those to the states for ratification, and 10 of those became what we now know as the Bill of Rights. 2 were not ratified at the time. There's an interesting story. One of them about limits on when Congress can raise its pay was actually ratified 202 years later and became what's now our 27th and currently last amendment to the Constitution. A side story on that. There's a fellow by the name of Mr. Watson who was working in the Texas legislature, or excuse me, was going to the University of Texas. He still currently works with the Texas legislature, and was doing some research on the Equal Rights Amendment and limitation that was pending and posing at the time. And he discovered this one of the 2 amendments that were not ratified at the time, and discovered the fact that there was no limitation on the time frame in which they could be ratified. And he started a letter writing campaign out to all the state legislatures around the country, and 202 years, and wrote a paper about that in his at the University of Texas in his political science class. And 202 years later, as a result of Mr. Watson's work, the amendment that was originally proposed by James Madison was ratified in 1993. It took 202 years later for that to happen. And the interesting sidelight about Mr. Watson, he had written a paper about this for his political science class. He got a C on the paper. you got a C on the paper, and then after the amendment ultimately got ratified and this man's work had changed the Constitution, he went back to ask the professor. The professor said it was still a bad paper. But it did change the Constitution. On December 5th, 1791, which next week will be 225 years, Virginia became the 11th of the then 14 states to ratify all those 10 amendments. And at that point in time, they became part and parcel of the Constitution. We often refer to things as amendments like they're something a little bit different, but the fact is Article 5, which defines the amendment process, says that amendments ratified pursuant to Article 5 for all intents and purposes become part of the Constitution. So amendments and the Constitution, they're all one and the same thing. So this is kind of a special anniversary. It was 225 years that it's been, those things have been in place and been part of our Constitution. So these guys kept their promise. Why was it important to keep their promise? We heard some great commentary today about the difference between a republic and a democracy. And the differences between republic and democracy are kind of extraordinarily important to why these guys kept their promises. We're going to discuss a little bit about how it is that governments operate, how they exercise their legitimate legal authority. And one of the speakers indicated that, of course, the founders were suspicious of direct democracy. And a famous quote that you guys probably ran across in your research on this comes from Ben Franklin. And Ben Franklin described democracy as two wolves and a lamb deciding what they're going to have for dinner. You know? And so these guys constructed a situation that would avoid tyranny of the majority. And that's what that was all about. But government needs a basis to exercise its authority over the people that it exercises its authority for. There's a... are we moving along here?
Natural law.
Okay.
Natural law.
But the government needs a basis for the exercise of its authority. I know there was a mention of different forms of government. Among them, sometimes it's dictatorship, where people get authority exercised over them simply by power. Sometimes there's been theocracies in the world where the government exercises its authority by claiming that it has a right from a deity to do that. Sometimes it's a monarchy. Monarchies have a situation where they kind of often combine dictatorship and a theoretical divine right of kings, situations like that. But the other way that got put in place with the Constitution and with the founding of the United States of America was never tried before, and it was a government based on a philosophy. And that philosophy had its basis, as we saw on the last slide, in natural law. We have a couple of things about natural law, but when a government is founded on philosophy, it needs four things, right? It needs the people to understand the philosophy, which is something that we're sorely lacking these days. That our people generally have not been educated on the founding philosophies that we have. But once they understand it, they have to accept it and believe that it, in fact, is legitimate. The government has to conduct itself consistent with the philosophy that it's founded upon. And finally, if people understand it, they accept it, and the government conducts itself consistent with the philosophy, then ultimately you wind up having to get the consent of the people. Once those four things happen in place, then the government has legitimate authority. And based on the Declaration of Independence, it established natural law as the legitimate authority for the United States of America. And so it was important for these gentlemen to keep their promises so that they ultimately could get the consent of the government, because the consent of the government is not just the ratification process, and not just an occasional election, but it's an ongoing and continuing presence in whether or not the government can operate legitimately. When it loses the consent, then it no longer becomes legitimate. And so they established natural law in the Declaration of Independence, when of course it began with when in the course of human events and finished up based upon the law of nature and nature's God. And from there, as Dr. Moss mentioned again, the Declaration of Independence is the basis for ultimately what became the Bill of Rights. We wind up with the unalienable rights that Thomas Jefferson indicates, life, liberty, the pursuit of happiness that we all know, and that the basis for the government and its legitimacy is, as he says here, they derive their just powers from the consent of the government. When we come to natural law, Thomas Jefferson covered both bases because there are actually two different schools of thought on what natural law is and what the source of natural law is. There's two different sources of thought. One is, of course, divine natural law that is inspired by and revealed from God. But there's another kind of natural law that strangely enough comes out in the same place. John Locke, who was a philosophical founder or philosophical mentor, if you will, to the founding fathers, was a big proponent on describing what would become called secular natural law, because it's not necessarily based on divinely inspired revelations. Secular natural law is actually based upon unchangeable and immutable laws of nature that are observed and recorded by the human mind. The idea is that humans by their very nature want to be free. Humans by their very nature don't want to be controlled. And by their very nature, they are inclined to self-preservation. They are inclined to defend themselves, their family. They're inclined to have the benefits of the fruits of their labor. St. Thomas Aquinas defined divine natural law as having these qualities of being inherent, inalienable, that it can't be taken away, and that it's indivisible, that it's one single portion of the universe, that it's at one with the universe. St. Thomas Aquinas discussed the ideas of divine natural law and how it was revealed through Scripture, both in the Judeo-Christian tradition, both in the Old and New Testaments, and this was divine inspiration, and that was St. Thomas Aquinas' definition of that, and the end result of that, of course, is that all men are created equal, with certain inalienable rights, and that are granted to them by God. Now, the secular natural law is the different situation. It includes inalienable, immutable, unchangeable physical aspects of the world. And so when the government tries to, and a great example of when you try and undo secular natural law, people's natural inclinations to be free, is essentially the 18th Amendment. When you put too much prohibition on people, they don't obey it, it doesn't work, and you have to repeal it. Government can't interfere with the natural inclinations of human beings just as a matter of course. A government, no matter, I mean, it can pass a law, but it won't have any effect if they try and decree that within its territory the law of gravity will not apply. Right? I mean, it just won't work. Although I'm sure somebody's tried, Senator. I'm sure there's some folks that have tried to defy the law of gravity within a legislative body, but they cannot do it. It just doesn't work. So very strangely enough, This is Locke's indication in the end result of Locke when he talks about people are born with these natural rights, liberty, equality, and an inclination for self-preservation. The end result is, whether it's divine natural law or secular natural law, they come out in the same place. And that was part of the genius of Jefferson's statement when he covered all the bases with the law of nature and nature's God, because he explained that circumstance to everybody, no matter their particular theological inclination, if they had a scientific inclination or a particular theological inclination. The end result is people come out with all men are created equal. They're endowed with certain inalienable rights, life, liberty, the pursuit of happiness. So it's to understand the Bill of Rights, you really do need to understand the philosophy behind it, that's behind them, that's expressed in the Declaration of Independence and the Bill of Rights, is really, really meant to execute and protect the inalienable rights that are described in the Declaration of Independence. The Bill of Rights, we've heard them. There are actually, if you identify them individually, 24 individual rights and protections and limitations on government that are placed in the Bill of Rights. You find them in the first 3 8th Amendments. The 9th and 10th Amendments are really kind of more related to intergovernmental and interrelationships between the government and the people on a direct level in the exercise of power. The first 8 amendments describe specific limitations for the protection of the inalienable rights that we're talking about. First Amendment, we're going to be talking about in a little detail in a while. Second Amendment, right to bear arms. Third Amendment, you can't have soldiers in your house. They can't keep soldiers in your house. The Seventh Amendment is the right to a jury trial in federal civil lawsuits. The 4th, 5th, 6th, and 8th are different in kind and degree from the other amendments. You don't normally talk about that. You frequently hear discussions of great things about speech and assembly and bearing arms. And those are obviously very, very important and key directly to the inalienable rights. 4, 5, 6, and 8 are all what I would describe as procedural rights. That says basically if the government wants to do something, it has to follow this pattern. And when it talks about what the government wants to do, we're talking more often than not for 4, 5, 6, and 8 about exercising its authority to take somebody's life, liberty, or property in the criminal justice system. I've spent 5 years as a prosecutor. I spent 20-some years doing defense work. So I lived with 4, 5, 6, and 8 in a courtroom almost every day for the last 25 or so years. And I don't think that people necessarily understand or appreciate what 4, 5, 6, and 8 do, because all the headlines, all the news stories, everybody screaming about the First Amendment and things like that. But the fact is if the government tries to punish your freedom of speech by putting you in jail for something called sedition or some other kind of activity, they have to follow 4, 5, 6, and 8 to be able to do that. If the government wants to do anything to you, to impose a punishment of any kind, they got to follow 4, 5, 6, and 8. And so 4, 5, 6, and 8 are kind of important. You know, we're kind of going to go with important. So procedures are these protections, and they may sound a little bit technical, but you know, these procedures are for your protection of your life, liberty, and in many respects property. So 2/3 of the Bill of Rights are devoted. You know, I mean, you might talk about quality when it comes to 1 and 2, but when it comes to quantity, you find 4, 5, 6, and 8 in the procedures that the government has to follow if they want to interfere with your right to life, liberty, and property. So they wanted to place these limitations on government for the purpose of doing that. And the first place they did that actually is in the Fourth Amendment. The backstories on so much, there is not a word in the Constitution that is not backed up by some sort of story or some sort of history.
That's right.
And to understand the words in the Constitution, it becomes important to understand the backstories. You can't understand what they're about. And as Madison would famously put it, every word in the Constitution decides a question between power and liberty. And so, and later, of course, John Marshall would also expound upon that. The fourth Chief Justice and the longest-serving early Chief Justice of the United States would expound upon that by indicating there is no word in the Constitution that does not have meaning. So Madison says every word decides a question. Marshall says every word has meaning. So nothing's there by accident. In the 1760s, before the Constitution, long before independence, but what very well may have set the stage for the road to independence, was the issuance of what they called writs of assistance by the King of England. And the King of England would issue these writs of assistance that would order local folks to assist the king or his agents in ferreting out all kinds of things. But these writs of assistance were what someone would call general warrants. That is, if you had a writ of assistance in your pocket and you said, oh, I got a writ of assistance and I don't think that this cross is a safe thing, I think I'm going to take it away, and we're going to determine whether or not the senator's breaking the law here. And that's all they had to do with a writ of assistance. There's a famous early colonial attorney by the name of James Otis that challenged these writs of assistance. James Otis was, despite his 5.5-hour summation, I'll try and be shorter. We'll try and be a bit shorter. Despite his 5.5-hour summation, he did in fact lose the case against writs of assistance. His loss of the case against those writs of assistance really perturbed all the colonies across. This case took place in Massachusetts, but all across the British colonies, they were disturbed. And the writs of assistance really, in many respects, although it's very complex, but in many respects you can say the writs of assistance, and James Otis having lost that case, really led to the revolution. It really led to the revolution. And ultimately, the writs of assistance case would lead to the Fourth Amendment. We've heard the Fourth Amendment read, but now it was written into law that you could not have such a thing as a general warrant that gave somebody plenary power to search or seize a person or property. And they could only get it with probable cause. So the writs of assistance in 1760 really led to the Fourth Amendment in 1791. There's a 31-year gap between the two, but people didn't forget, which of course many of our contemporaries have forgotten. Many of our contemporaries think that it's okay for people to monitor our cell phone calls, or think that having our emails collected by the NSA is okay in the name of national security, and they forget. And that kind of conduct is actually a modern writ of assistance.
You bet. Yeah.
It's a modern writ of assistance. It's a modern circumstance where they do not get a specific warrant that names a particular place or person to be seized based upon probable cause. And that's what happens when you forget history. When you forget history, then you wind up in a situation going, oh, it's okay for these folks to do that. And of course, another Ben Franklin thing. Ben's on the cover of my book. I used to do as a sidelight, I used to do a radio show called Constitutional Soundbites, and I often thought that Ben Franklin would have been just one of the world's greatest radio hosts. The modern age would have been made tremendously for Ben and his quips and his sound bites. And of course, he's famously known to think that people that don't value security over liberty will soon have neither.
Amen.
And so that's the story of the writs of assistance and how we wound up with the Fourth Amendment. So people, if they're going to search and seize your property, this is a procedure that's locked in that they're supposed to do, and it becomes up to us to defend it. Fifth Amendment. Handsome guy over there. Ernesto Miranda. Fifth Amendment actually has 5 rights, much like the First Amendment. We're going to get to the First Amendment rights before we're done, but certainly among the most well-known is the right to remain silent and people taking the Fifth. People can't testify against themselves, or they're not allowed to testify against themselves, or it's not used unless, of course, they've waived that right. And this is another story that I'll leave alone, but frankly, this story traces back to Sir Walter Raleigh in the 1500s. You're shaking your head. You did some research. You ran across Sir Walter Raleigh, no? Yeah. But in 1966, there was a fellow by the name of Ernesto Miranda who was accused of a violent crime against a woman. He was arrested, taken into custody in Arizona, kept in police custody for over 4.5 hours, and when he came out of police custody over 4.5 hours, they had a signed statement from him that admitted everything that they were saying that he did. Ernesto was ultimately tried and convicted based primarily on that statement. So ultimately, Ernesto's attorneys would challenge his conviction all the way to the United States Supreme Court. And the United States Supreme Court ultimately would say that even though you have rights, these rights exist in the Constitution, but if people don't know them, they don't understand them, they can't exercise them. And so, as a result of Miranda versus Arizona, we wound up with what's now known in both police work and popular culture as the Miranda warnings. They ultimately became ubiquitous in society, and people had to be advised by the police once they were under arrest of their right to remain silent, of their right to counsel. Supreme Court, when they did this is a sidelight on the Fifth Amendment situation, and Ernesto was arrested. The Supreme Court, he was convicted. The Supreme Court overturned his conviction based on the fact that he had not been given the benefits of counsel, or he had not been advised of the right to remain silent. Ernesto was sent back to Arizona. He wasn't freed. They overturned his conviction. He was sent back to Arizona, and Ernesto got tried again. And this time they tried him again, and they didn't use his statement, and actually he was convicted again. And he was sentenced to about 5 years in prison. He served his time, got out on parole, and not long after Ernesto Miranda was released, he was making a living signing autographs as Ernesto Miranda of Miranda warning fame. You know, so he was going around making a living doing that, but he also liked to shoot pool. And he wound up in a bar in 1976 in a pool room in Phoenix, Arizona. Apparently got in a fight over the outcome of the pool game, and a melee ensued inside the pool hall and the bar, and Ernesto Miranda was killed. He was murdered in that pool room. The police rounded up, and strangely enough, I've had occasion as a state's attorney to try barroom fights. It's very, very difficult to do that because everybody saw something different happen. And nobody really remembers very well what was going on. But the strange thing about Ernesto Miranda's murder was they did round up everybody in the barroom, and it was quite clear that among the people they rounded up, they had Ernesto Miranda's killer. You know, it was pretty obvious because nobody had left, and they rounded them all up. But everybody that they rounded up in the bar where Ernesto Miranda was killed got the Miranda warnings. Nobody talked. So nobody was ever convicted of killing Ernesto Miranda because his suspected killer and everybody around him got the Miranda warnings. So anyway, that's the right to remain silent. That's kind of how some of that applies in real life. They've got there's 4 other rights. We've heard them today during the wonderful reading by the kids. And so now let's talk about another fellow that had a situation in a pool room. Sixth Amendment has 6 rights. Go figure. Fifth Amendment has 5. Sixth Amendment has 6. These are all, again, procedural rights. You have a right to a speedy trial, right to a public trial, right to an impartial jury, right to be informed of charges. Again, another sidelight. That didn't, while it always makes sense, it didn't always take place. People were often tried without being told what they were being tried for. That was part of the colonial story with the British. You'll find that complaint in the Declaration of Independence. Most of these things that you find in 4, 5, 6, and 8 result from the complaints that Thomas Jefferson wrote out in the Declaration of Independence against the King of England. So the connection between the Declaration of Independence and the Bill of Rights is just so close. Right to be informed of charges, confront witnesses against him, and there's Mr. Clarence Gideon, who in 1960 was arrested for burglarizing a pool room. Go figure. But it was in the panhandle of Florida. And Mr. Gideon, when he got walked into court, told the judge in the courtroom that he wanted a lawyer and couldn't afford one. The judge said, "So what?" And they tried Mr. Gideon. He was found guilty of burglary and a few other assorted minor crimes, and sentenced to 5 years in Florida State Prison. Clarence Gideon famously sent a handwritten appeal to the United States Supreme Court. It was just written on a piece of paper with a pencil. It's preserved today at the Stetson Law School. Strangely enough, the Dean Emeritus of Stetson Law School was the Florida Attorney General that would take this case to the United States Supreme Court and lose. Great man. But at any rate, Gideon would write this letter to the Supreme Court and said, judges, and it's just kind of handwritten out, and said, guys, and they were all guys in those days. Guys, I asked for a lawyer, the judge didn't give me one, I got convicted, I don't think that's right. Now, up to the point when Gideon wrote this letter, there was a limited right to appointed counsel in certain federal cases. There were no rights to appointed counsels in any state cases. There were no rights to particularly appointed counsel. The right to counsel had been interpreted over the previous 150 years as you had the right to hire a lawyer. You didn't necessarily have a right to have a lawyer. You had the right to hire a lawyer. Certain federal felony cases that had been evolving over the years, but at this point in time, In state courts, there was no public defender system. There was no system. Occasionally, judges might appoint some local private lawyer to do something. But when Gideon wrote the letter, even though he had made that demand in state court, there was no guarantee under a Supreme Court decision for that to happen. Gideon's letter turned out to be the case of Gideon versus Wainwright, and Wainwright was the director of the Florida State Prison System that Gideon sued for his release. And the Supreme Court said, you know, what good is a right to an attorney if you can't afford one? And so the Supreme Court at that point in time said, you know, if you can't afford a lawyer, the state has an obligation to appoint one for you. So the Bill of Rights not only stated stuff in 1791, it's evolved and expanded in some ways since 1791 to make it more applicable to more of society than it may very well have been. But before Gideon, nobody actually contested that situation. The backstory on Gideon. Gideon was had his case overturned for burglary of the pool room, and Gideon, after he had his case overturned, was sent back to Florida. He got tried again, and he had an appointed lawyer. Lo and behold, the jury in about 45 minutes found Mr. Gideon not guilty. Mr. Gideon was freed as a result of his having had a court-appointed lawyer, and his case reformed the criminal justice system throughout the United States of America. But strangely enough, Mr. Gideon's case, the philosophy of Mr. Gideon's case was adopted largely through most of the common law countries of the world. The Supreme Court of Canada agreed with it, the Supreme Court of India agreed with it, the Supreme Court of Australia agreed with it. Mr. Gideon's little handwritten letter to the Supreme Court changed the way criminal justice systems were handled all around the entire world. So the impact of these things, when, you know, it's very strange. Dr. Moss referred to something called, and referred to some of these things as uniquely American. And sometimes when I think of the term American exceptionalism, I think of these kinds of things, these kinds of ideas that reformed actually not just the United States, but actually the world. Gideon's little case, his little burglary of the, I take that back, his alleged burglary, and he's not guilty, reformed the criminal justice system around the entire world. There were some other considerations in one of the last principles of one of the procedural aspects of the Bill of Rights in the Eighth Amendment. We talk about no cruel, unusual punishment. There's a couple other provisions there. One is excessive bail. The excessive bail provision was certainly something that grew out of the colonial experience. They would set bail at numbers that people couldn't possibly afford. And so folks were essentially put in jail for all practical purposes without a trial and held forever. You'll find a complaint like that related to that, again, in the Declaration of Independence. But the cruel and unusual punishment situation. The Supreme Court, in the years since the Eighth Amendment has been around, indicated that there were certain punishments that were obviously cruel and unusual. Drawing and quartering is considered to be obviously cruel and unusual. You can't dissect somebody in public. That's considered cruel and unusual. You can't burn them alive. Go figure. And of course, I'm not sure what the difference is between dissecting and disemboweling, but the Supreme Court made a distinction and said you can't do either. The interesting thing about these four particular punishments for crime that have been found to be outlawed by the Eighth Amendment. Of course, on July 4, 1776, or shortly thereafter, it passed over time. But at the final word, the final sentence of the Declaration of Independence indicates, with reliance on divine providence, we pledge our lives, our fortunes, and our sacred honor. All the guys that signed that were committing treason.
Right.
They were committing treason against the king. They were, in fact, placing on the line their lives, their fortunes, their sacred honor. The penalties for treason at the moment that those guys signed the Declaration of Independence were, in fact, not just one of these. They were ordered to be drawn and quartered. They were ordered to be disemboweled. They were ordered to be burned alive and dissected in public. That was the risk that those guys were running when they signed the Declaration of Independence. And strangely enough, we now say that that's cruel and unusual because we did not want to be what the English were and what the English were threatening to impose on Americans. The penalties for treason under English law were exactly what was outlawed by the Eighth Amendment. And so when you consider, again, the history and understand what's going on with the Eighth Amendment, you have to trace back the history to be able to understand what it is. So those are the amendments, 4, 5, 6, and 8, that deal with procedural matters that have to do with protecting your life, liberty, and property. They have to do with protecting your speech, your exercise of your religion, your exercise of freedom of the press. Because if the government wanted to interfere with your exercise of freedom of religion, speech, press, assembly, what do? They arrest you, right? They arrest you, they lock you up, they send you to jail, they give you a fine, they threaten you with a fine. So, how do you protect them? You literally protect them with 4, 5, 6, and 8. And I think it's really, really important for folks to realize, you know, you can talk about your speech, you can talk about your religion, but if there was not a structure in place that literally protect those matters, the protections would simply be on paper, and they wouldn't mean much. And we're going to talk about protections on paper in just a second. Those are that's the essence of what we've been talking about here. We're now going to.
They were amazing. I mean,
really?
The crowd is just.
Is this crowd really good?
This crowd, yeah. We could take them on the road with us.
We could take them on the road.
I mean, we've got dinners tonight.
We're going to go back to the First Amendment, and we're going to answer the question. And my beautiful assistant, also known as my sister, indicates that this group is amazing in terms of their answers. We have 5 rights in the First Amendment. They're freedom of religion, freedom of speech, freedom of press, freedom of assembly, and the last one, which I would indicate as the capstone in the last one, is called petition the government for redress of grievances. Now, that's one that most people miss, most people don't think about, most people don't understand. Now, if you think about speech, press, religion, assembly, big rights, right? Really, really important stuff. Petition for redress of grievances. You think the guys that wrote the First Amendment put that in there by accident? You think they put it in there by accident and put it in with these really big things without thinking about it on purpose? They didn't. In the period before the Constitution, and in the colonial period, in the early days of the Republic, people actually had the right to take a petition to the legislature and have the legislature entertain the petition, to hold hearings on it, to vote up or down. People often in those days submitted their own drafts of laws. That would be really kind of difficult to cope with these days, no, Senator? But the people actually would put together their own drafts of laws, and the legislature was obligated to vote on it. These petitions were submitted by men and women and children, and even in many circumstances, slaves. And so this was the tradition that existed at the time the right to petition for redress of grievances was written into the First Amendment. In the 1840s and 1850s, the United States Congress was inundated with petitions to limit or abolish slavery. Democratic-controlled Congress was being extraordinarily embarrassed by these petitions to abolish slavery. They didn't want to entertain them. They didn't want to think about it. They didn't want to have public hearings. They didn't want to have any debate about it. So little by little, they quit listening to them. And actually, at some point, they created a rule in the House of Representatives called the gag rule that prohibited the reading of petitions for the abolition of slavery. That happened in the 1840s and 50s. Later on, after the Civil War, the gag rule technically was repealed. But by the 1860s, by the late 1860s, the right to petition for redress of grievances had disappeared. There's a cautionary tale in the right to petition for redress of grievances. That cautionary tale is that if we don't exercise, if we don't defend, if we don't work with the rights that we find in the Bill of Rights, those rights can and will, in fact, disappear. Right?
Yep, that's right.
Because we have already lost. I mean, it's still on paper, right? It still exists there. We can read it, everything like that. It's still on paper, but it's like, the best word I can say is vestigial. You know, sort of like some people still are able to wiggle their ears. You know, but it's not with particular effect. It's still there on paper, but it doesn't exist in reality. And if we don't do that with the rest of our rights, we run the risk of losing all of them. And the obligation, when you talk about the government enforcement, the obligation is on us. The obligation is on us.
Amen.
Sure, if anybody has a question, I'll do that. If not, yes, sir.
Yeah, you mentioned the 9th and 10th, and it says no nobility. Can you enlighten us on the original 13th Amendment?
How much time do you have?
Titles of nobility, of course, are not, prohibitions on titles of nobility are not in the 9th or 10th Amendment. They are, the prohibitions on titles of nobility are actually within the body of the original Constitution as unamended itself. But
Section 9 and 10.
Pardon me?
Section 9 and 10 of Article 1. Sorry.
Section 9 and 10 of Article 1. I'm sorry. I was referring to, when I talked about 9 and 10, I was talking about the 9th and 10th Amendments. But Sections 9 and 10 of Article 1 indicates that nobody will take titles of nobility. And the controversy of the original 13th Amendment, I have some familiarity with because they say that somebody accepting the title of Esquire is not allowed to serve in the federal government, but I would
also known as lawyers.
that would be the crowd. That would be the crowd, and that's the alleged or alleged original 13th Amendment that seems to have been lost in some places. But I would suggest to you that the title of Esquire these days is traditional and not granted by another foreign government. When you're talking about a title of nobility, you're talking about sir, or being knighted by the Queen, or given a title of a lord, or something you find on Downton Abbey.
Wasn't it passed in like 1824, 1828?
You know, I'm familiar with it. To be perfectly honest with you, I didn't study it quite a bit because it certainly turns out to be issues for attorneys.
Yeah. But my question was, because what I saw was 1824, 1828, they found all the ratified copies.
Yeah.
Why did it take all the way till after the Civil War, during the Civil War, for it to get turned over to, the no slavery? You think in that year, in that, 4 years,
There were several proposed, there was different proposed 13th Amendment that actually was proposed to constitutionalize literally slavery. And then there was the Titles of Nobility Amendment that was allegedly ratified. So there's several things within that time frame that were at issue. That's not the only one, but to be able to trace those documents around in the various state legislatures in the early 19th century, I can only tell you that sometimes it would take 6-7 weeks for ratification news from Virginia to get to Washington, and so some things have been lost. There's actually some controversy about actual ratification of the 14th Amendment as well. There's some details that you can trace to some kinds of issues regarding history, and the quality of the records that the state legislatures kept in those days as to the ratification. But regarding titles of nobility and the prohibition for lawyers, I would suggest that the term esquire, that some people argue is a title of nobility, is not really a title of nobility. It's no different than saying attorney or anything else. It's just a traditional thing. So that argument is kind of silly. Yes, sir.
One quick, this is the last question, and plug the book.
Oh, yeah, okay. Yes, sir.
Plug the book.
As a descendant of former slaves,
Yes, sir.
I've often entertained the thought, maybe you might have insight or not, how could you put together such a document as the Constitution of the United States of America and yet feel that you could enslave people?
There certainly was a problem for the founders. There was certainly both a moral and otherwise political dilemma. I will tell you this, and not necessarily to make excuses for them. I can tell you that if Gouverneur Morris, who ultimately was the penman for the ultimate Constitution in the end, worked very, very hard to make sure that the term slavery did not appear in the document, so that the institution did not become constitutionalized, so that there was the ability to be able to get rid of it. Now, to judge this generation by our morals, by the things that have happened, if you judge what happened on September 17, 1787, when they created the first self-governing people in the world, if you look around the rest of the world when they created this situation and put in motion a circumstance that would ultimately lead to the abolition of slavery, the rest of the world was run by kings and czars and chieftains and sultans, and there were slaves all around the entire world. These guys put together a system, and with their soaring rhetoric and their promise of equality, put together and created the circumstances that would ultimately lead to the abolition. I can make no defenses for the southern states that even through the 1840s and 1850s, which was their dedication to maintaining that institution that led to our losing the petition for redress of grievances. Can I mentally justify it? No. Can I say that it's probably not right to judge by our current standards? Yeah. Can I also say that they are the guys that put in motion the situation where where 170 years later, Martin Luther King could refer to the Declaration of Independence, and he could refer to that, he could refer to the rhetoric, and he could refer to the rising expectations. When you consider that for the 10,000 years of human history, that kind of institution had existed both for white and black, for all races that were enslaved. Certainly the Romans would enslave the peoples that they conquered. You know, it didn't matter whether they were African, whatever color they were. So there was a tradition of slavery through 10,000 years of human history. And these guys created a circumstance, and Gouverneur Morris particularly worked hard to make sure that term was not in the document, so that that document did not make the institution permanent. I understand that was my last question. As my beautiful assistant over here reminded me, I do have a book called Constitutional Soundbites. It would be for sale in the back. I will be autographing copies for those of you that choose to do so. It is 150 frequently asked questions about Declaration of Independence, the Constitution of the United States of America, and the Bill of Rights. We put them together in a way that, you know, unfortunately these days, although I've learned something new about this group, you probably have read the Federalist Papers. That's not the likely conduct for most folks these days. Most folks these days are used to getting things like tweets and blog posts and things of that nature. And so we put together 150 frequently asked questions and answers. What did Jefferson mean by all men are created equal? One of the more interesting questions in the book, I think, is what can a president legally do with his pen and his phone? But thank you very much. I appreciate it.